In Wisconsin, first degree intentional homicide, which is the first count in the criminal complaint, by law starts originally in adult court. So it is not a juvenile juvenile case brought into adult court. While he's still a juvenile, it's an adult court case.
Can you tell us the other charges and what your plan is for this case as far as keeping it in adult court?
So the three charges he has is first degree intentional homicide. The second count is first degree sexual assault. The third count is first degree sexual assault to a child under age 13 resulting in great bodily harm. Regarding keeping it in adult court, I think it's premature to make any determinations regarding that at this time. I think it's a very serious case that needs to be dealt with as is intended by the law.
How was this case solved?
That I cannot get into.
Could you explain the differences between the second and third counts, the two sex assault charges?
Sure. So in Wisconsin, it's first degree sexual assault. That means regardless of the victim's age, it's an assault.
Okay.
Then in Wisconsin, we have a separate section that deals with sexual assaults involving children. So so that's the difference. Is the first charge applies to the victim of any sexual assault. Count number 2 would only apply if the victim was of a certain age.
Is this filed publicly then, or is it technically not filed publicly?
So it was filed publicly, so when I handed the paper copy of the criminal complaint to the clerk, that was my process of filing it. As you probably heard from the judge, what the public will have access to is limited by his court order.
Which means?
I'm not going to answer as to what his court order means.
District Attorney, the next hearing next week is to determine his counsel, is that correct? And when is the initial appearance for this defendant?
So technically today was the initial appearance. Charges were filed. The next step would be a preliminary hearing. He waived the time limits for that, so it's next week is just a status to see if there is new counsel on board.
What are the
talk about what this has meant for your office in this community? This is some very quick police work, very quick work by your prosecutor's office. Talk to me about all the people that went into this for this moment.
Chief Kelm would probably be a better person regarding that, of knowing everyone that was involved. I know he gave a press release yesterday thanking everyone who was involved. I am aware of the Chippewa Falls Police Department being involved, the Chippewa County Sheriff's Department being involved, the L.T.L Police Department being involved, the Division of Criminal Investigation for the Attorney General's Office for the state of Wisconsin being involved, the Crime Lab being involved, as well as a bunch of other jurisdictions as well. But I will forget to name some, but there was a lot of people involved in this, following leads, doing great police work to determine what decisions would be made regarding further investigation and going forward with investigation into this matter. I know that the community was very concerned to begin with, because without knowledge as to who an offender is, that is a very concerning matter for the community. I have a 17-year-old daughter myself, and I know that the school, because she plays soccer, the school mentioned that the coaches would make sure that there weren't any, as much as possible, any kids going alone or anything like that. So that's a very terrifying thing for parents to have to deal with, is to worry about, can my child be the next victim of a crime? Until you find out who you believe the perpetrator to be, that is very concerning. And I appreciate all the hard work that law enforcement did to at least bring it to this point in time. And it's not over now, but bring it to this point in time so the community can at least know regarding this matter that they're safe because the defendant's in custody.
Mr. Newell, you've had some awful cases involving children in your county, and then now this. What is this like for you going through?
It's difficult because it's just knowing how it impacts other people is very, I guess, my empathy is more with others than myself. It's just the nature of why I got into this and the work I do. My specialty, other than being the high profile cases like this, is sexual assault cases in general. Those are very hard cases that very time consuming, very emotionally draining. But I guess the way I look at it is, and it goes back to my daughter, is I try and be the prosecutor I would want if something happened to my daughter. And so that's the way I look at things, and not try to get too emotionally impacted on it, but just do the professional and do what is necessary to have justice done.
You alleged in court that this was intentional. And you said that the suspect left that home with the intention to do, and you listed some of the acts here. And did you say that he had confessed to that point? Could you just speak to what you spoke of on the?
Yeah, so when I said yes, the statements that I made in court were, I think, if I didn't clarify it, was statements from the defendant himself to law enforcement. So the information I relayed was based upon the statements the defendant himself made to law enforcement.
So those are contained in your complaint then? Those are the allegations
Correct.
outlined that you said there. And then could you speak to, again, what you spoke of in there, of the actions, the intentions, and then the actions that occurred?
Like, restate it?
Yeah.
Because the thing is, right now the judge has sealed the criminal complaint, so I can't just read from the criminal complaint. No. And unfortunately, I don't have a good enough memory as to what I said or did not say. So
you said he left the home down the path with the intention to rape and kill.
Yes, I do remember saying that.
And that he punched her, knocked her down, hit her with a stick, strangled her.
I believe I mentioned all those things as well.
How does that information change your prosecution? That timeline and those specific alleged acts.
Yeah. So I mean, obviously you don't have the criminal complaint in front of you like you may in other cases, but all three of the charges require that the defendant intended to do something. So like first degree intentional homicide, it's with intent to kill a person. So that you have to that's different than like reckless or some other version of homicide, that you went into the situation with intent to kill the person. And obviously sexual assault is you have to intend to do those sexual acts. I mean, I don't know how they would ever be accidental, but that's the law requires that they be intentional.
That's based on his statement to investigators.
Yes, in part.
What are the penalties for these?
How is the defendant related to the abuse?
That I cannot get into at this time.
They leave. You mentioned in court they left the home together to go down that path.
Yes, I believe that's what I said.
What are the penalties for this in adult court, and how does that change if you move it to juvenile court?
It's just to be clear, it's in adult court now. So the punishment for count number 1, it's a Class A felony. Upon conviction, shall be sentenced to life imprisonment for life. Count number 2 is a Class B felony, punishment not to exceed 60 years. Count number 3, which is the sexual assault of a child charge, is also a Class A felony, and upon conviction shall be sentenced to imprisonment for life.
And not less than life. Is it mandatory life?
No, not yeah.
Up to life?
Up to life.
Okay, and then if you move it to juvenile, how does that change?
There are no sentences in juvenile court. People are adjudicated delinquent and get court orders, but they're never sentenced. So I can't say he'd be sentenced to something in juvenile court because that's not a possibility.
Is there a chance this could move to juvenile, or is it there's no way that you can, since it's first degree murder?
So there is a process by which the defendant could petition for, we refer to it as reverse waiver, is to bring it back into juvenile court. The statutes and obviously there are statutes involving that, and the burden is upon the defendant to make the showings under the statute that it should be back in juvenile court.
I would guess you would oppose that.
I'd have to wait till I don't do anything just reactionary to anything. Everything I do is based upon the totality of the circumstances as I know them, and I would never want to prejudge anything until all the facts were presented to me.
Have you seen any mitigating factors in this at all?
I can't get into the facts of the case.
Will anyone else be charged in this case, like charged for obstruction or anything?
You would have to talk to law enforcement in regards to that, and my guess is if they're looking at investigating other individuals regarding, say, obstruction, that they probably wouldn't let anyone know that until the investigation was done.
And Wade, just to clarify, that Class B, you said 60, that's 40 years incarceration, 20 years extended, right?
That's the total sentence, but yeah, because
Right.
yeah.
I just wanted to clarify the way we say
Yeah,
it.
we're a truth in sentencing state, so all of our sentences are broken down to periods of initial confinement and periods of extended supervision. So all those sentences are broken down that way. Obviously, other than if you get a life sentence, then it's life with the possibility of extended supervision at some point in time.
Can you speak to when you believe this intent was formed?
Once again, that would be getting into the facts of the case, which I cannot do.
Can you explain the bail situation? They wanted 100,000 because of his age. You went with $1 million and got that. Why did you want it to be so high? And
Given I guess I'll just reiterate what I said. While his age was a concern for me, his intentions and what he said his intentions were and how he carried out his intentions in the statements that I made in court are why I thought it was, I guess in my mind, an aggravated situation that called for protection of the community up at that degree, and the concern that given the penalties he was facing, that he would decide to leave the area. So even though he may not have a driver's license given his age, everyone in this world has access to someone who can help them to be somewhere else.
In your career, have you ever seen somebody so young do something so gruesome?
Yes. I mean, some of you may have been there. We had the individual, I think she was 10 or 11 years old, involving, and this was almost exactly right around the time of the vehicular homicide situation involving the Girl Scouts. So,
Is there one thing you could point to that helped break open this case for you? Was it a tip from the community? Was it detectives pounding the pavement?
and I feel bad because I want to answer your questions, because a lot of them I can. I mean, in my mind, I know the answers to it, but once again, that gets into the facts of the investigation, which I can't get into.
Where was the defendant seated today during the hearing?
The Eau Claire, say the full name of it, the Eau Claire Juvenile Detention Center?
Secured. We just refer to it as, so it's JDC, so it must be Juvenile Detention Center. Would be my.
Who are the attorneys sitting to his left?
Carl Schmidt.
So then it would be juvenile defendant/defendant. Then it would be Kirby Harless, and then Carl Schmidt.
And why the decision to have them appear on video versus in person?
That decision was made by the court, not myself.
Hey, you know the family a little better than us. There was no family that you saw in the courtroom, right?
I personally have not met the family myself, so I wouldn't know how they are. I can tell you that over the course of the last couple of days, have been in ongoing contact with law enforcement, dealing with various things, dealing with search warrants. So I haven't been directly in contact with the victim's family. I know that Sherry Dockel, the victim witness coordinator in my office, has been, as well as the victim advocates from the Wisconsin Department of Justice.
Do you know why the exception was made for the siblings? Was there anything to that?
I'm not going to speak to the mindset of the judge regarding making orders.
Why was it requested, I guess, in the first place?
Regarding the siblings, I don't think it was requested. I think the judge just brought it up himself.
Oh, okay.
Could be wrong about that, but that's my understanding.
So are the search warrants still sealed as well, and the criminal complaint currently is sealed?
I know that we have done orders to seal search warrants that have been done. I don't know if the court has signed those orders to seal, because the the order to seal is presented by a law enforcement, not by me. But I know that orders to seal exist, or that motions to seal exist.
And then last, I guess, what's next? I mean, we have this fellow court appearance. What's the timeline of the legal process from here?
I guess it's more in the hands of the defense to make their determination as to how they want to proceed regarding keeping it in an adult court or not.
What happens at the next hearing then in May?
Just for them to advise the whoever his attorney is, I guess his current attorneys or new attorneys, to advise what the next step will be.
What factors go into that decision, making it, keeping it adult or going?
I don't want to speak to the mindset of a defense attorney.
All right, thank you.
Thank you.
Yep.
Could I get your first and last name and spelling?
Sure. Wade, W-A-D-E. Newell is N-E-W-E-L-L.
Is it district attorney or county attorney?
District attorney.
Okay. Which is the county?
Which is the county, yeah. But we're not county attorneys, like Minnesota, I think.
County, yeah,
attorneys,
district,
but-
yeah.
Y'all have a good day then?
Thank you, sir. Appreciate it.
Thank you.
I did not say.